So this part of the presentation will be the Certificate of Need Roadmap. Maureen Weaver of Wiggin and Dana will be providing an overview of the Certificate of Need process for nursing homes and residential care homes as amended by the 2022 legislative session. So Maureen, I hand the presentation over to you.
Thank you very much, Meg. So Meg had suggested that we hold this session providing a CON roadmap for a couple of reasons. One is that, as mentioned before, and as many of you know, there were some very significant changes made to the CON laws in this past session. But just as importantly, we know that it's not every day that members of Leading Age deal with the CON process. It might be once every many years that you encounter it. And there are many specific provisions and requirements and twists and turns and procedures involved. And so we really thought that it was a good time to have a session that will take as much time as we need to here up until 4 o'clock to review the CON requirements and procedures, highlight the new provisions, and give you some sense of how this process works. We also anticipate that there could be more activity in terms of CON filings, largely stemming out of the April 1st plans that you all were asked to file with the Department of Social Services. And so I think DSS is expecting that there might be some increased activity as well. So let's jump right in here. The first question is, well, which providers are subject to the DSS CON process? And as Meg mentioned, it's really nursing homes, both CCNHs and RHNSs, residential care homes, and people often forget ICFMRs are also responsible for complying with the CON requirements. There's a big exception in terms of nursing homes that came into play a few years ago, and that is that nursing homes that are affiliated with continuing care facilities, that's CCRCs, when those nursing homes do not accept Medicaid, are exempt from the CON process. And that's a very important exception. So they're exempt from the entire process. They're also exempt from the moratorium on additional nursing home beds, and we'll get to that in just a moment. Now it's very interesting because, as many of you know, there's a separate CON process for hospitals and substance abuse and mental health providers and diagnostic imaging companies and other types of healthcare organizations that resides under the Office of Health Strategy and Department of Public Health. The nursing home, the long-term care piece, has always been separated out into DSS, and I think for good reason. The legislature, I think, recognized that in these types of facilities, such a large percentage of the population are Medicaid recipients, and these facilities rely so heavily on the Medicaid program to support them and for primary revenues that I think it was felt that it was very important that the CON process stay within the state Medicaid agency. So that's how we're set up here. So when is a CON required? Now, there's actually two separate statutes that map out reasons or situations that would require a CON. Many of them have been in place for years and years and years. The first is when there is a transfer of all or part of the ownership in the facility or control in the facility before initial licensure. Now, this shouldn't be mistaken for a requirement that there needs to be a CON for every CHOW or change of ownership. That's not what this is interpreted to say. It's actually pretty dated. It goes back to the time before the moratorium, or just right after it was imposed when people were, completing their new facilities, where if you were to transfer ownership before that particular facility got its very first license, that is when you would need to get a CON. And I think I was involved in one of these. I'm dating myself, but it was like back in the 90s when Marriott, the hotel chain, owned property in Stamford, Connecticut to develop an assisted living facility, and they ended up transferring ownership over to Stamford Health System, which built what is now known as the Edge Hill Retirement Community. So that's the only time I've ever encountered this provision. The second piece is when there's a new function or a service expansion. In long-term care, the services are usually, pretty common across the board, not specialized, except in a few cases that we can discuss. So this doesn't get applied very often. The third provision does get applied more often, and that's when there's a termination of a service or a decrease substantially in total bed capacity, and that would include any nursing home closure. So this is the provision that triggers the need for a CON when there's a closure or a big bed reduction. And then finally, relocation of all or portion of beds to a new or replacement facility also requires a CON. Believe it or not, it wasn't 100% clear in the CON laws over time, but fortunately that's been relocation and replacement facilities have been clarified. A separate statute deals with situations where you have capital expenditures that exceed certain amounts. That's reflected here. That would be when you're engaged in renovations. You might have gone through a change of ownership and you're required to make certain renovations by the Department of Public Health as a condition of approval. And so the CON is required when your capital expenditures exceed $1 million, but then only if there's an increase in facility square footage by more than 5,000 square feet or 5%, whichever is greater, or any capital expenditures exceeding $2 million will require a CON. So before we get into the procedures for pursuing a CON, we really need to focus on the moratorium statute. It's in the CON statutes, and it's highly relevant because there are a lot of provisions in the moratorium statute that are relevant to the CON process. So the nursing home bed moratorium, very important to remember, it only applies to nursing homes. It doesn't apply to residential care homes. So I've been involved in a number of matters where new folks have come on and decided to build small or medium-sized residential care homes, new beds. Obviously, they go through a bed need analysis in the CON process, and they're thoroughly scrubbed and assessed by DSS before the CON is granted. But they don't have any restrictions; they can build new beds. Nursing homes cannot, and they haven't been able to do so for 30 years. There are exceptions, however. Some of these exceptions, there's 5 exceptions in total. The first, several have been in place for many years now. The first one is an exception for AIDS beds or beds needed for neurologic rehabilitation. That goes back to the days when we had TBI units in nursing homes. The second is non-Medicaid beds associated with the continuing care facility. I'd mentioned before that continuing care facilities with nursing homes that won't participate in Medicaid are exempt from the entire CON process, and they're also exempt from the moratorium. So they can not only be exempt from the CON process, but they're also exempt from the limitation on building new beds. Now, it's interesting because this particular provision was really complicated. It was an exception that it took like 3 pages in the statute books to describe all the elements that you had to prove to show that you qualify for this exemption. It was quite onerous. I went through that process with many clients over the years. Luckily, that was all removed about 3 or 4 years ago. And even further revised this year, because it used to be that you also had to show that your ratio of independent living units to nursing home beds was going to be sort of within industry standards, and that was taken out of the statute. So this is good news. The third exception is for Medicaid beds that are relocated from one facility to another, and that is to meet a priority need under the state's long-term care strategic plan. Now, this was sort of also dates back. It originated back in the time when people were buying beds and selling beds. We don't have that anymore. DPH doesn't allow it, but it's still feasible that one facility might decide to relocate beds from one facility to another that's within their chain, or has some sort of a deal with another owner where they would like to relocate beds. So it's not out of the realm of possibility that this might come up. The fourth exception is one that really has been, I think, mostly kind of added to over time, and it has to do with Medicaid beds that are relocated from one or more existing facility to a new nursing facility, including a replacement facility. So finally this year, that was added in, And it's clear that this particular exception applies to replacement facilities. But there are several, 7 in all, conditions that need to be met. No new Medicaid beds can be added to the system. At least one facility in the process needs to close. And that facility, if you're doing a replacement facility, that will be the facility that you're replacing needs to close. The relocation needs to be done within available appropriations. The facility must participate in the Money Follows the Person program. Bed availability in an area of need cannot be affected. Obviously, you have to get CON approval. And then facilities included in the facilities are included in closure and relocation they're involved in closure and relocation must be in accordance with the long-term care strategic plan. In other words, you can't be closing down a facility in an area of need. You can't be adding a facility where we're in a region that's overbedded, and all of that will come out in the approval process. So the new exception that was just added on as of July 1st of 2022, that covers proposals to build a non-traditional small house style nursing home. Doesn't have to be small house, but small house style nursing home that's designed to enhance the quality of life for nursing home residents. And that's provided the nursing facility agrees to reduce its total number of licensed beds by a percentage determined by the commissioner under the long-term care strategic, or consistent with the long-term care strategic plan. So this is really interesting because it's an exception to the moratorium on new beds. So initially when you read it, you think, that means that if I build a small house, I can add more beds to the system. But that's not the way this is worded, because it says that you can only do it if the facility agrees to reduce its total number of licensed beds. We really pushed back at DSS and pointed out that this didn't make any sense, but they didn't seem to think it needed to be clarified. So it's sitting there as an exception to the moratorium, but it seems to me that it's not intended to permit new small house beds, new nursing home beds through small house or small house style, but it's really covering situations where someone might be building a replacement facility and they would wish to build that as a small house style facility. So what are common reasons for CONs right now that we're seeing? We're seeing a lot of bed reduction. And in a few moments, we'll cover the special DSS procedure for non-substantial bed reductions. We're seeing renovations that meet or exceed the capital expenditure thresholds. That comes up from time to time. And often there's a combination of the two. There's a bed reduction, but there also needs to be a massive renovation of the facility because you're going to be adding more private rooms, taking down shared bathrooms, opening up community space. You're exceeding the capital expenditure threshold, so you're really doing both. Closures, we've had closures occurring, here and there over the last many years. Replacement facilities are starting to become more and more common here. That's one reason. And then kind of as we look more to the future, and maybe not too far out to the future, we might see CON applications to establish the small house or small house style facility, likely as a replacement facility or as a renovation of an existing facility. We might see that provision about the need for a CON when you're adding services get implicated, because we're seeing a need for specialized services such as ventilator care, dialysis, and bariatric care. Those types of services might require will require, I assume, CON approval, and it may be that DSS will come up with some sort of a procedure to follow to obtain that CON approval. And then the relocation and consolidation of facilities. We might see more and more of that, maybe pursuant to some of the April 1st plans, or maybe just sort of organically as time marches on. We might see more relocations and consolidations over time. Okay, so I also wanted to set out a list of resources for you all in terms of the CON, and right here I've listed all of the statutes that apply to the certificate of need process, as well as the statute that covers the long-term care strategic plan, which is a little elusive because no one ever really fully understood what it was or where it's set out. We think it's set out in that 2020 strategic rebalancing plan, but I know some of the data behind that plan has been amended by Mercer. So you have your statutes. I highly recommend that you refer to the Public Act 22-145. It repeats the statutes verbatim and contains all of the new amendments that took place in 2022. If you go to the statutes online, you're not going to see the new amendments. The online statutes don't really get amended for some time. They'll probably get amended by sometime early next year. So for the time being, make sure that you refer to the Public Act, and the legislative summary that we provided to you as a link to that Public Act. There's also a link here to the DSS, portion of the DSS site that explains the certificate of need process, particularly for nursing home bed reductions. There's also a link to another link that DSS actually provided to us that takes you right into the section that contains the 2020 Strategic Rebalancing Plan report, as well as other information about where to get data about bed occupancy levels, et cetera, in the state. And then I always tell people that it's really helpful to look at prior DSS CON decisions. They're not posted like OHS posts their decisions. You can see final decisions that are issued in proceedings. They're much more organized and formal than the DSS process. But you're entitled to get them under the FOI. And I think there are many decisions sort of get floated around informally from one colleague to another and one facility to another. So if you knew of another member that went through the CON process, I'm sure people would be willing to share their final decision and even talk to you about how they went through the application process. Now, let's get back down to the procedure here. So how do you start the CON process? Well, there's always an opportunity for informal discussions with DSS. This isn't new. DSS has always indicated that they're willing to discuss plans before the formal process begins. In the past, they've sort of clammed up and not been as willing to talk to people once there's a formal proceeding, but in advance of that, they're open to having discussions. And that can be quite helpful because there might be something that you're looking to do that doesn't necessarily require a certificate of need approval. And you can discuss that with them. If there's anything that's sort of on the edge or that you might want to have documented, you can always discuss that with them, and they might suggest that you send them a letter of intent, and then they would issue a determination that a CON is not required. One example might be if you are a continuing care retirement community and you're looking to add additional non-Medicaid beds, that's exempted from the moratorium. It's also exempted from the CON process, but maybe you're doing a renovation and your bank's going to want to make sure that you don't have to, that you've gotten any approvals that you need, and you can obtain documentation by going through this letter of intent process. Now, the formal way to start the CON process is through the letter of intent. And the letter of intent is submitted, and by submitting the letter of intent, you receive any special instructions and the application from DSS. Once you get the application from DSS, you're supposed to wait 10 business days before you actually file the CON application, or it's 10 business days after the letter of intent is submitted. And then your letter of intent is actually good for 180 days. That's a pretty long time. It gives you plenty of time to go through the CON application and submit it if there's any delays along the way. If you miss the 180-day timeframe, it's really not that big of a deal to file a second letter of intent. As you'll see, it's a pretty straightforward process. Now, the letter of intent must contain specific content. It must contain the name of the applicant, the reason for the CON. Is it a bed reduction? Is it a replacement facility? Is it a renovation? Is it a combination of all of these things? You have to provide an estimated capital cost. It doesn't have to be documented at this point. It's just an estimate, and you'd be well advised to say that it's just an estimate. You have to indicate the town where the project will be located and a very brief description of the project. Also note that the long-term care ombudsman must be notified when a letter of intent is submitted to DSS. So I always tell people it's probably best to just copy the ombudsman on your letter of intent when you send it to DSS. Okay. There are some special procedures that are in place now for low utilization and for elimination of 3 and 4 bedded rooms. And these procedures are all mapped out through that link to the DSS website for CON that I provided in an earlier slide. So when you submit, if you submit a letter of intent for a quote unquote non-substantial number of beds to reduce, DSS may issue a determination letter just granting to the request and not requiring that you go through the entire CON process. Now, DSS, we've actually posed the question to DSS very recently. Well, what do you consider to be quote unquote non-substantial? The DSS response was that generally speaking, it would be fewer than 10 beds or fewer, or 10% of the facility, whichever is less. But they are going to review each of these applications on a case-by-case basis. And if there are facilities that had a history of terminating beds, that'll be reviewed, and that could impact whether or not it's going to be considered non-substantial. In other words, the writing between the lines here is that you can't do this by attrition. You can't reduce 10 and then come back in 6 months and reduce 10 more. They'll start looking at the pattern here and the impact on the total facility complement. Substantial number of beds reduced, that's a different process. So shortcut, potentially get a quick determination. I know several members who have already done that. It happened very quickly. They got a response right away. They were able to go to DPH and get those 10 beds or fewer delicensed. If you have a substantial number of beds to be reduced, DSS has a process that falls into 2 categories. The first is when this occurs in the context of reducing or eliminating 3 and 4 bedded rooms. In those cases, you need to submit your letter of intent. DSS will give you a short form CON application, and then they're going to consider the applications in the order in which they're received. Different process if you're reducing a substantial number of beds due to low utilization. This is a full-blown CON process. So you have a full CON application, it must be filed, and it gets batched when it's filed. So they have batching where if CONs are deemed complete by March 15th, that's one batch. And then there's a separate date of September 15th for CONs that are deemed complete by September 15th, so that after September 15th or March 15th, the earlier date, that CON is going to get considered and decided by DSS. Some people have asked whether or not the batching process is still in place, and we did confirm with DSS just earlier this week that it is still in place. So they're still doing the batching. Now, special requirements for substantial bed reductions. In addition to filing the letter of intent, you also are required to send a written notice to residents and their representatives and post the notice in a conspicuous location at the facility. And the special notice will obviously inform the residents that you're looking to reduce X number of beds, that you filed a letter of intent with the Department of Social Services, that you anticipate that your CON application will be filed on fill in the blank date. The notice has to say that only DSS has the authority to grant or modify or deny your request, that DSS has up to 90 days to do so. You need to give a brief description of why you're making the request. You need to assure the residents that no one will be involuntarily transferred just because of the CON filing. And residents will have the right to appeal any proposed transfer or discharge if they're asked to be transferred or discharged from the facility. You also have to provide the long-term care ombudsman's contact information. This particular notice requirement has raised some operational issues and some issues with the ombudsman's office for some facilities that have had to go through the process, in that, a lot of times once the notice goes out, people start wondering, well, does that mean my unit's going to close? And if my unit's going to close, I need to go talk to the social worker or the administrator to discuss whether or not perhaps, I can get on the list to move to another unit. I don't want to have to leave the facility. People get concerned and worried, and there's discussions that take place. And I've seen some situations where some of those discussions have been misconstrued by the ombudsman, who's interpreted them as the facility initiating the discussions, trying to clear out a unit before there's been any CON approval for that. So, that's just something to be aware of, that there's a lot of noise around that, and it has to be really carefully navigated. Now, when there's a substantial bed reduction, another special treat that is in store for you is that DSS is required to hold a hearing at the facility not later than 30 days after receipt of the CON application. And by the way, this is the same process in place for closures. There's a notice of the public hearing that is issued 10 days. It's provided to the facility and it's published. It's provided to the public. Now, the one exception to this, and this is really helpful that we were able to get into the law, is that the hearing is not required for CON approval that's requested for the relocation of a facility or a portion of the facility's licensed beds to a newer replacement facility. There were a couple of instances where there were replacement facilities, and this was back maybe a few years ago, that the Ombudsman's office advocated and argued that this is like a closure of the facility, the original facility, even though it's not. Everybody's going to go to the replacement facility and have a nice new room there. But for some reason or other, the Ombudsman prevailed upon DSS to hold a hearing, which was very confusing to all the residents and sort of like an unfair process. And that's not going to happen anymore. It got changed, thankfully. Special note about closures. We could give a whole half hour or 45-minute session on the closure process. I'm not going to do that here. It doesn't happen very often with nonprofit providers, but just note that they're very special detailed CON procedures and other regulatory reimbursement and operational considerations involved. So, it's really advisable to consult with legal counsel if that's something that's in the future for you. CON application. So the CON application is actually quite a piece of work. DSS has been sort of revising it and tweaking it over time, but it takes a lot of time and effort to complete the CON application. Just so people are aware, it's not something that you can just sort of slapdash out very quickly. And you are going to need your experts and your consultants to help you with various aspects of the CON application. The average CON application has maybe 14, 15, 16 different questions, and each of those questions have detailed subparts. There's a need to provide data, there's a need to provide reimbursement calculations, etc. DSS generally does expect some project details, for example, preliminary design drawings, if that's applicable. They want to know that you've been in touch with DPH about your project, and they will even want to know whether or not you've gone to DPH and what stage you're at in the approval process. And they're always very interested if there's going to be any sort of renovation, that you've been in touch with DSS about the phasing project for any kind of construction that's going to take place. Are residents going to be moved at different points in time? What are the details, and have they been worked out? They're going to want detailed project budgets. And most importantly, they're going to want to know how that affects Medicaid reimbursement to the point of actually wanting you to calculate the rate. So in addition to having your architects and maybe even your general contractor involved, if you've selected one yet in the first tranche, you're going to need your reimbursement specialist to help you, or your internal or external reimbursement specialist to help you developing the budget and also figuring out the Medicaid rate impact. They're also going to want to know that you are making arrangements for financing and know your financing plan. What they really like to see is a commitment, but as many of us know, the banks aren't going to give you a commitment until you have your CON approval. So, but they want to know that you're in process there. And then there are many questions that address the DSS criteria. That's criteria that DSS has to be met before issuing a decision, and we'll get to that in just a few moments. Okay, so now DSS's review of the application here. So DSS has to issue their decision within 90 days of a quote unquote completed application. And what is a completed application? Well, that's an application that it's not just the first draft or the first application that you send in. It's possible that once you send in your application, indeed, it's pretty standard. The DSS will request additional information. These are called completeness questions that you'll need to respond to. And you'll need to respond to those questions to DSS's satisfaction before they'll deem the application to be complete. So then the 90-day timeframe starts running once that occurs. Now, one new really helpful provision we were able to get enacted into the law this year was that during the CON review, DSS may hold an informal conference with you. And this could be quite helpful if DSS is unclear about some aspect of your application. They would like there to be clarification that it's not really helpful to just keep sending you questions back and forth. It might be more helpful and more efficient for the parties to just sit down and have a conversation. Now, our intent here was that this isn't something that is exclusively in the domain of DSS to initiate. If you, in my view, if you wanted to ask DSS for an informal conference, as you can see, they have the discretion to hold it. I wouldn't be shy about asking for one if you think it could be helpful. Prior to this enactment, DSS was taking a very formal position on having any communications whatsoever with CON applicants. They would not talk to people over the phone. They wouldn't agree to have meetings. They would only do this through very formal Q&A through these completeness questions, and it was very difficult in many circumstances. So this should be helpful. DSS also is not required to hold a hearing on the CON application unless it's what we discussed before, which is a substantial bed reduction or a closure. They may hold a hearing. They're, as I said before, but they're not required. If they do hold a hearing, they may hold an informal conference with the facility before the hearing, which can be very helpful again, because it can sort of limit the issues that need to be addressed, make sure that the applicant has, a good sense of what DSS's expectations are through the hearing. Now, I think it would be very helpful for us to go through, well, what are the criteria that DSS considers when reviewing all CON applications? And there's a special statute, 17B-355, that maps out the criteria that have to be considered. And that statute was enacted, in a fairly extensive way in this past legislative session. It was kind of cleaned up. There were references. Some of you have been through the CON process, know that it used to be that they would ask that you submit or you comment on how your CON application affects the state's health plan. And if you Google health plan, it's like some old health plan from 2010 or 2014 that DPH developed that has nothing to do with long-term care and doesn't even mention long-term care much at all in the body of the document. So that all got cleaned up, which is good. So here are the items that have to be considered. Financial feasibility, obviously. The impact on the Medicaid rate and the financial condition of the facility. And I have to say that actually should have been highlighted here because it seems to be their driving concern, is what is the impact going to be on the Medicaid rate? If there are capital expenditures for renovations, there's going to be a request to increase the fair rent portion of the rate. That's always the focus. And there's extreme attention paid by DSS to all of the components of that fair rent calculation, weeding out items that aren't allowable, questioning items that you've included that are allowable. So that's quite a process. They also look at quality, accessibility, cost effectiveness, and there's very specific questions touching on each of these items in the CON application. Public need, the utilization impact, both for the applicant and the general service area, which we consider to be within the 15-mile radius, whether there are any specific business interests, positive or potentially negative of the owners, sponsors, directors, et cetera, and any other factor that DSS might deem relevant. So those are sort of the standard consideration. And there were some new ones that were added in this past session, particularly affecting replacement facilities. So for relocation of beds to a replacement facility, DSS previously had to consider an obvious question, which is what is the bed need in the 15-mile radius? But new considerations include whether or not there's going to be an adverse effect on bed availability in the service area, which is kind of the same thing. That there should be no increase in the number of Medicaid beds, and that at least one facility must close in the process. And we talked about this before, that facility would be the facility that's the old facility that's going to be shut down and replaced. In addition, DSS may consider in an application for a replacement facility whether the bed reduction is consistent with the long-term care strategic plan. And then the second one was sort of a bit controversial, and that is that if the applicant owns or operates more than one nursing facility, that DSS may consider the need to close 2 or more facilities. So not just the facility that you're replacing, but another facility that you may own in your chain of ownership. And this was controversial mainly for for-profits. And I think originally it might have been a shall consider or you must close down, and that was modified during the legislative session. Now, another item that DSS must consider for a replacement facility is, and this is actually sort of follows the theme of the small house and the current commissioners favoring of that style of facility, all for good reason. And that is whether a new or replacement facility will be a non-traditional small house style facility that incorporates the goals set out in the long-term care strategic plan. And this criteria specifically focuses on the need for it to promote person-centered care, provide enhanced quality of care, create community space for all nursing home residents, and develop stronger connections between residents and the surrounding community. So again, that was a very important consideration here, particularly with respect to the new commissioner or the commissioner. And it's unclear whether, it does say DSS must consider this, and it's unclear whether DSS will interpret that to mean that every replacement facility has to follow this model. We know that the small house model just won't work within certain types of footprints, or it might not make sense. And so we were hoping that this language was softened enough in referring to it as a small house style facility and listing all of these different attributes, that if you had a plan that wasn't traditional small house, but touched on, or not just touched on, but covered all of these points, that might be compelling enough to get approved. Now, how and by when must the DSS decision be issued? Of course, we said the commissioner must grant, modify, or deny the application within 90 days. And, I stopped there for a moment because some people think, yeah, it's either yay or nay, but there's a middle ground here. The commissioner could come in and say, well, we don't think you ought to reduce it by X number of beds, but we're willing to approve your application if you reduce it by 10 fewer beds, something like that. Now, in a new provision is that DSS may place conditions on the CON approval in addition to just granting, modifying, or denying it, to address specific concerns. And I'm putting this, I put this in quotes here, largely because these are the words of DSS that got put into the statute, and Mag and I didn't have a clue what they meant. We thought they were just shorthand and they were going to, try to improve their drafting, and we asked them to, but they never did. So project and Medicaid reimbursement details and applicant requirements for summary and audit purposes. Again, we're not sure what that all means, and hopefully we'll find out at some point. Now, one other important element that was added here is that if DSS is thinking about issuing a modified decision, they have to notify the facility first and provide an informal conference so there can be a discussion about it before the final decision is issued. And this was a really positive step as well, because it really opens up for more flexibility, that if DSS before, I think DSS was either, kind of routinely just either granting or denying. I hardly ever saw modifications. We have seen a few. I think this opens the door for more of a give and take here, and it doesn't necessarily result in an outright denial. Now, as far as the decision is concerned, you'll see when you review DSS decisions that they sort of follow a routine standard. They provide background. They review all of those factors that we talked about: accessibility and quality of care and consistency with the long-term care strategic plan. They have specific findings for that project, and then they issue an order. And that order itself may contain some of these conditions already. They routinely do. For example, the order part of the decision will always have some sort of an expiration date, that this approval is effective for X number of years. It depends on how big the project is. And there are sometimes opportunities built in to request an extension of that. You also need to go back to DSS if there are any material changes in your plans that vary from what DSS approved. You also have to go through various categories of that. The order will go through various categories of costs, or the findings will, and state what is allowed and what is not allowed. For example, the capital financing pieces, development fees and marketing are not allowed. They go very, very particular about what they'll state as allowed and not. And then the decision always includes a caveat that the approval is good for now based on the current law, but if the statutes should change in the future, it might not be permitted. And it's only going to be permitted if the statutes aren't contrary in the future. So you can't lock it in. There's some risk that statutes could change in the future. One big variable that we always encounter is the fair rent portion of the rate. That it seems like there's nothing embedded in the statutes permanently that guarantees that the fair rent will be covered in your rate, but from year to year, from budget to budget, we get language in the statute that the commissioner is permitted to increase the fair rental amounts based on CON approved modifications. So that's something that comes up. Now, what's interesting here is that it didn't used to be this way. There was a time when DSS had a habit of issuing agreed settlements. They were settlement agreements that became incorporated into a final order of the commissioner, but there was opportunity for some give and take in terms of how the decision came out. That's not the case anymore. DSS has taken a much more formal route. And I just mentioned that because it's so rarely that you all encounter the CON process, and some of you might recall that many years ago, maybe under Commissioner Starkowski, there was an opportunity for this sort of give and take and having an agreed settlement, but that's not the case anymore. Okay, so now how can the DSS decision be issued? Some more on this. If there's a public hearing held on the application, the commissioner can assign a designee to do the hearing, and that designee will submit findings and recommendations to the commissioner. The designee typically is someone who works in the Office of CON and rate setting, and typically it's been probably in the past either Betsy Boyvid or Richard Wysocki. More recently, it's been Betsy Boyvid. Now, what's new here is that if the designee recommends denial, then they must issue a proposed final decision, and the applicant will have an opportunity for briefing and oral argument on the proposed decision. Now, the statute doesn't say the applicant will have opportunity for briefing and oral argument, but it says that they will issue a proposed final decision pursuant to, and there's a cite to the Administrative Procedure Act, which allows for briefing and oral argument. So you do have an opportunity if there's a denial, and the denial is issued by someone, not the commissioner herself, but someone she's designated to, weigh in on it for the commissioner to consider. The commissioner then issues the decision to grant, modify, or deny, and it can also place conditions on the CON decision. So there's two situations. One is there's no hearing, and it follows the process that I just reviewed before. And then if there is a hearing, most likely the commissioner's not going to sit through a hearing. She's going to designate someone to do the hearing for her. And so you follow this process. So we're coming to a close almost here. So what happens next? You get your CON decision, and if your CON is denied, it's best to consult with legal counsel as soon as possible on your options, because the timeframes for doing anything about that could be very short. If there wasn't a hearing held on your application and you get a denial, the CON statutes actually explicitly permit the applicant to request and receive a hearing if they're aggrieved by the decision. And the other thing is that the Uniform Administrative Procedure Act provides the right to request reconsideration of any agency decision. And the reason I said this is a short time frame is that you only have 15 days to file your request for reconsideration. And so that then jettisons it back into the agency. They have an obligation to decide whether or not they're going to reconsider. You have to make a really good case for them to reconsider, because they only have to reconsider if you can show that there's been an error of fact or law, or there's new evidence that's been discovered that could materially affect the merits of the case, or there's sort of other good cause. And then if the CON denial is upheld after any kind of a hearing, then the applicant can appeal to the Superior Court. So that concludes our CON roadmap, and I'm happy to open it up for any questions now.
Thank you, Maureen. That was a great overview of the process. I know it can be so confusing, having worked on it all session. I know how confusing it can be, and determining where your request falls. But we do have a question in the chat, and that is, do all of us have to go through the CON process, or is it just for those looking to reduce bed capacity? I guess assuming maybe they're talking about their April plans.
Oh, yeah. It depends on what your April plan says. So you really have to go back to the portion of the slides that I covered that list the reasons or the situations where you need to obtain a CON. And so I think if you're reducing your bed capacity, if it's not substantial, you probably would get by with just filing a letter of intent, and you get a determination that you don't need to go through the CON process. But it really depends on your project and whether it meets those provisions. And like I said before, DSS, I think the commissioner reiterated that, Meg, at the board retreat we had last week, that, come to DSS and discuss your project. She invited people to do that. And DSS will help you figure out what you need to do to get it approved.
And it's the first several slides in the presentation where Maureen outlined when a CON is required. So if you go back to those slides, there's certain situations where it is required. The next question is, what if the project changes during execution? For instance, excess costs, other unforeseen needs?
Yeah, if there's a material change in the project, you need to go back to DSS and let them know about it. And there might be some sort of a modification to the order that they issue, but better to bring it to their attention sooner than have them find out about it later.
Any other questions? You can either put them in the chat, or you can just unmute yourself and ask the question. I just want to comment, I think one of the more hopeful changes that we were able to get into the process this session was that ability to speak with DSS and have sort of the collaborative discussions during the process, because previous to this, they had taken the position that they couldn't speak to you once you had filed your CON. And so this would allow for some modifications, or sometimes just a better understanding of what you're putting forth in your CON. Some of the suggestions would be to really not, you're putting in a CON because you're reducing the beds, but tell the full story. Give them the bigger picture of why you're doing it. Or say you're adding on a wing or doing some modifications. Tell the bigger story of how this is enhancing the lives of the residents, or, enabling you to do other services out in the community. Because the CON's been so specific, and Maureen, correct me, often the CON was very specific to this specific issue you were doing, but it may help you to get approval or a more beneficial ruling if you provide the bigger picture.
Right, and I would say that's especially true if you're looking to you're a as you all are, you're a high quality facility and you're looking to reduce beds. DPH obviously would rather that you not reduce your beds, but that others who might not be so high quality do so. But if you're doing that, but you're going to be taking the additional resources that are available, or part of your mission, you're going to be then expanding and providing community-based services that will also benefit Medicaid recipients. Tell that story. Make sure they understand the full picture.
All right. Well, I don't see any other questions. We did record this presentation and we will soon post it onto the members only section of our website. So if you need to go back and review it, or if you have others in your organization, or maybe even your consultants would like to review it, if you're determining future plans, we're really pleased to have this as a resource to you. And we want to thank Maureen for putting this presentation together and offering it for you today and allowing us to post it on our website. So thank you, Maureen, and Jermaine, I see you're still online. Thank you so much for your previous presentation. We really appreciate it. And thank you all for joining us today.
Thanks, everyone.
Thank you.